Right. Pallavi, thank you so much for bringing us the latest on this. We'll continue to track all developments on this. And now moving on, more information which is just coming in. Criticism of judiciary in school textbook storm in the Supreme Court. Centre has tendered unconditional apology to the Supreme Court over the mistake. CJI says it's a very, very calculated move. It's not just the student but the parents and teachers would be imbibed with this thought that the judiciary is corrupt. So remember, there's this entire uproar over the content on a Class 8 textbook of social sciences. For more on this, we have Arunima with us. Arunima, of course, the CGI has taken cognizance of the matter. He yesterday also said that the law will play out as it does. And of course, going forward, that's something that we will see as well. What can you tell us?
So, the center has tendered unconditional apology. What the Solicitor General said was that the two people who were responsible for these paragraphs getting included in the draft textbook of NCERT for Class 8, those two people have been acted against and an assurance being given by the SG that they will not be associated with any ministry in future, which means that there's punitive action that is following. But what the court observed is that the bullet, and this is, I'm quoting the observation, that the bullet has been fired and judiciary is bleeding. Not just students, but even parents will be under this perception the judiciary is corrupt. Those observations could find some kind of a resonance because the final order is also getting dictated as we speak. Ananya Bhatnagar is there inside the Supreme Court. But since the Centre too has apologized, it could be that the final order could be more in line with noting the submission that has been made by the SG, and if any directions are required in the Supreme Court could pass that as well. But it is very clear that the court has taken very strong note of what the proposed textbook wanted to say about judiciary.
Absolutely, and he'd made that clear earlier as well. Now, that being said, he's also said that this is a rather calculated move, Arunima. What do you assess from that?
So that has been the apprehension. Yesterday also when senior members of the bench, Kapil Sibal, Abhishek Manu Singhvi, they were all present when this matter was brought to the attention of the Apex Court. And at that stage also the court had said the law will take its own course. And today also the observation seems to be that even though the SG said that, the onus is being put on two staff members and action is being taken against them, the judiciary, it seems, is of the opinion that this was not something done by two people or three people independently. The judiciary is apprehensive that this was a well-calculated move, which means somebody wanted to tarnish the image of the judiciary. And I think that will find an echo in the final order that is being dictated.
Right, of course, Arunima, also we know that this is not an isolated incident. In the past as well, we have seen there have been accusations of how text has been perhaps molded to fit, has been moved around to fit a certain mold. That is something that we have seen in the past. Also, that being said, when we talk about such sort of decisions which are being made, do you think there is going to be further changes in the review process when it comes to corrections, revisions and additions?
Let me just read out the order as it is being dictated. This is courtesy Ananya, who's there inside the Supreme Court. The order says framers of our Constitution were profoundly conscious and took abundant caution to ensure that constitutional provisions as such were inscribed, and that the three pillars of this country, which is the executive, the legislature and the judiciary, they remain capable of operating with respect to autonomy while functioning in the democratic fabric. While acknowledging constitutionally prescribed demarcation, we were in shock when one of the leading newspapers published an article regarding release of the social science textbook for grade 8. So that shock has found mention in the final order. And Chapter 4 of the publication is titled Role of Judiciary in Our Society, is what the order has noted. That expression of shock itself is something that is now going on in the judicial records. The court is expressing shock that such a decision was taken, and the order is being dictated further. So you could find more, references to what the judiciary really thinks. If it gives directions in the for future as to how such chapters should be incorporated, if there are any directions given as far as punitive action is concerned, that is what we are waiting and watching.
But of course, there are also others who may be opposed to this entire saga altogether. We've seen some of the reactions which have been coming in widely by the public. How do you think this is being received, Arunima?
See, ever since the cash scam knocked at the doors of the judiciary, we all know how at the residence of a judge, there were smoldering currency notes found, and since then even though an impeachment process is underway. Since then, Judiciary has been battling this perception about corruption. So in that backdrop, for a textbooks proposal, proposed textbooks to have this kind of a reference to Judiciary, I think the court has taken note and has said that we were shocked that this has been mentioned. There was one line of thought from the bench as well as from the bar, that why are you targeting only one institution? Like the order also that I just read out mentioned that the constitution makers had very strongly spoken about autonomy of all three pillars, which is the executive, the legislature, and the judiciary. And there are instances of corruption that have been found in every institution. Executive corruption, we all know. Time and again, we hear of ministers and bureaucrats getting arrested by CBI for corruption. Legislature, who can forget Shibu Soren, the late Shibu Soren under cloud then. There were a lot of allegations made back then of currency being brought in a huge suitcase, and subsequently there was another instance where the Bharatiya Janata Party had alleged that cash was being given for votes. So legislature too has seen that taint. Essentially, what the members of the bar and the bench feel is that by only mentioning judicial corruption in a proposed textbook, you're being unfair to one institution and trying to change public perception towards the institution of judiciary. That, I think, is what is being noted in the order as well.
Right, and of course, Ananya Bhatnagar, as you mentioned earlier as well, Arunima is bringing us more updates. The CJI says that it seems to us that there's a calculated move to undermine the institutional authority and demean the dignity of the judiciary. This, if allowed to go unchecked, will erode the sanctity of judicial office in estimation of public at large within impressionable minds of the youth. That being said, Arunima, of course, there's more information and updates coming from the inside as well. While the publication dedicates entire chapter on role of judiciary in our society, it washes away the illustrious history of the Supreme Court, the High Court and the trial courts. Now, Arunima, of course, there are going to be a lot of questions over where do we draw the line then, in fact?
So the final order too has noted what was observed, that the court feels that this was a calculated move. So even though SG said that the two people responsible have been acted against, the apex court is not convinced. They feel that it was a calculated move, and it goes on to record in the order that we are looking at the manner in which the illustrious history of the High Court and the Supreme Court has been missed. But we are only focusing on the allegations of corruption. So all of this are going as a matter of record in the judicial order.
Right, Arunima. Of course, this all this information being brought to us by Ananya Bhatnagar. Of course, there the CJI also saying all the publication dedicates entire chapter on the role of the judiciary in our society. It washes away the illustrious history of the Supreme Court, the High Court and trial courts. It submitted the role played by the institution towards preservation of democratic fabric. The text fails to recognize the role of judiciary, which upheld the basic structure doctrine. So that being said, as of course these are very important parts of the order as well, Arunima, what will you be looking out for?
I think the directions, if there are any directions, because the NCERT keeps updating its textbook time and again, and there is a system under which the NCERT textbooks are updated. So it will be interesting to note if there are any directions from the court about the way these textbooks are updated, the kind of content and the kind of scrutiny that it should go through, because the court has made it very clear that it feels that this was a calculated move to tarnish the image of the judiciary. This was not a one-off incident or not something that just happened as a matter of error, or that error is to be attributed to one person alone or two people alone. So that is something that the court has recorded in its order. We'll have to wait and see if there are any directions that are given.
Right. So once again, for the benefit of our viewers, if we could just take you through some of the pertinent bits of the order that's being read so far, brought to us by Ananya Bhatnagar. The CJI says that it seems to us that there's a calculated move to undermine the institutional authority and demean the dignity of the judiciary. This, if allowed to go unchecked, will erode the sanctity of judicial office in estimation of public at large within impressionable minds of the youth. While the publication dedicates entire chapter on role of judiciary in our society, it washes away the illustrious history of the Supreme Court, the High Court and the trial courts. It is omitted and the role played by the institution towards preservation of the democratic fabric, and the text also fails to recognize the role of judiciary, which upheld the basic structure doctrine. Arunima, as you were mentioning earlier, there is of course a battle when it comes to the perceived image of the judiciary in light of all the recent developments as well. So there is that battle also.
And I think that's what the court means when it observes that its apprehension is that this was a calculated move, because it feels that there is a ongoing campaign against the judiciary. We all know how the collegium system of selecting judges promoting them, transferring them. That entire collegiate system has been under attack as well. At some point, the government had contemplated whether a national judicial accountability bill should be brought back. We also heard then Vice President Jagdeep Dhankar on the floor of Rajya Sabha had spoken about the NGAC and how a judicial accountability law should be brought in. So all of that is in the backdrop when the bar and the bench are expressing concern that this attempt to change the book is not a one-off thing, or it's not something that has been um, made an error of judgment made by one person. The judiciary feels that this is a calculated move, and I think even though the centre has rendered unconditional apology and has assured that action is being taken, the court is not, completely convinced that this is a one-off incident. The court is of the view that there should be proper scrutiny as to how this draft proposal really was passed.
Right. Also joining us right now is Simran. Thank you so much for joining us, Simran. What can you tell us?
Well, absolutely. In fact, as the court has really wrapped up the NCRT over this very chapter, it has also underlined that they have mentioned about the corruption and dedicated the entire chapter in the social science class 8 textbook, where the CGI has also commented and highlighted that they have not really shown and they have not really made an attempt to contribute to also give a chapter or to underline the essays which have given the sense of the role that has been played by the Supreme Court, High Court, and the trial courts in upholding the doctrine. And also going on to say that this is, in fact, as my colleague Arunima was also telling, it is a calculated move if we speak of what really the CGI has to comment on these intentions as well. As earlier, in fact, these comments have also been made into the contention, given the kind of intention with which this entire chapter making the corruption as an issue over the judiciary has been brought with.
Right. And Arunima, if I could just come back to you on that as well, there are more observations which have been shared with us by Ananya, of course, saying that the necessity of the judicial intervention is not from a desire to suppress criticism. And that really is the pertinent bit, and also something that had raised a lot of concerns when we, of course, first saw the uproar with regards to the certain sections of this social sciences book. Arunima? All right, Simran, let me come to you on that. More observations being shared with us by Ananya as well. And of course, this is being seen, it has been made clear by the CJI that this is necessary, and it's not from a desire to suppress criticism, but to uphold the integrity of education and, of course, also the integrity of the institution.
Well, absolutely. In fact, the NCRT has now very hurriedly decided to remove these chapters. And after the comments that have come from the CGI, clearly, in fact, on the dissent note with which the intention of the chapters that have been introduced in this case for the Class 8 book have, as highlighting how exactly there is a calculated move at large, given the corruption and how exactly the nexus in judiciary has been put in forward, but not really talking about how exactly the contribution of the Supreme Court, High Court, the trial courts has largely been over these years into really being a very strong pillar of the democracy and also upholding the doctrine of the democratic structure as well.
Right, that being said, when it comes to such corrections being made or such sort of revisions being made to textbooks, as Arunima was mentioning earlier as well, there could be some directions which are given by the court. Simran, what should we be expecting on that front?
Well, I lost your audio. Can you please repeat the question?
Right, can you hear me now, Simran?
Right, I can hear you.
Right. So, Simran, I was just saying, when it comes to directions which we may be expecting, what would you be looking out for on that front given by the court?
Well, after the SC wrap, the NCRT has quickly, in fact, speedily tried to remove the chapters, and this is what we can expect now. While there are many such revisions that the NCRT at large and over curriculum they try to make, but given the kind of case that has now this turned into, in the future going ahead, this is going to be a textbook example of how not making such revisions without the consultation of the institution or exactly that kind of a pillar in the democratic structure is going to be taking place, as this particular matter has also exploded the kind of light with which the judiciary or the judicial system has also been put into. And that is why it is very important for the curriculum over how exactly the NCERT is now going to have a consideration and deliberate, in fact, discussion over the kind of revisions which will be made going forward in the future. Also, the Ministry of Education is also going to look into this matter very closely, how the revisions will be made and the consultation should be going forward, in fact, put into complete discussion.
Right. So, of course, we are bringing our viewers more observations. Simran, if you could, for the benefit of our viewers, quickly take us through the timeline here and the observations from the court.
The NCRT just 2 to 3 days back had decided this is the second volume of the social science chapter, which had these references of how exactly there has been a rampant corruption in the judicial system, and this was never, in fact, earlier a part, but in the earlier volume one book or part one book, this reference was there last year in the class 8 book, and this was released last year. But this particular chapter would have been a part of the curriculum going forward from the next academic session. And only, in fact, within a matter of 2 days, this matter has reached the Supreme Court. And after that, the CJ has taken a turn, cognizance of how this has put a very bad light on the judicial system and overall the judiciary that has been disrespected. If I have to quote the comments that have come from the bench as well, highlighting how exactly there has been a calculated move at large by the institution to also, in fact, at this point of time, make an attempt to defame the judiciary and to also, in fact, put this into a bad light. And that is why the NCRT now has decided to speedily scrap this chapter, which had these references which became contentious.